Hello and welcome to the Tuesday Tech Talk series. It is my honor to welcome Professor Haochen Sun, who is Professor of Law at University of Hong Kong, to give today's talk, which, as you can see, is about his wonderful book. If you're not subscribed to the ISP newsletter yet, that's how you get updates about our events for the week. I also want to do a quick shout out for Data Remakes the World, which is our wonderful spring conference that Aaron is running this weekend. Registration has reopened again, so take advantage of the window and register if you haven't already. Without further ado, welcome, Haochen. We're pleased to hear your talk.
Thank you, Chimai. It's absolutely my delight to talk about my book today and such a nice venue. Immediately when I walked in, I immediately felt I would be giving a talk, in a family setting. So this is great. And I just told Professor Balkan that his work has, profoundly influenced my writing. And so it's absolutely my privilege and honor to present my book today at the center that he founded and he directs. And before I delve into the detail of my book, I want to quickly talk a little bit about the background information, mostly about what has motivated me to work on this book project. So first of all, the COVID-19 pandemic. I think most of you do not want to talk about it, but anyway, that's what I learned from the pandemic. I found that technology was a very important, part when we were dealing with the pandemic. And for example, internet access turned out to me as a very serious social problem. And so if you can recall, at the very beginning of the pandemic, a lot of students shifted their learning online, and you can see that according to the statistics, around 15 million students shifted to online learning in 2020 in the United States. But surprisingly, nearly 1/5 of them did not have reliable internet access in their homes. And also the research showed that as of February 2020, nearly 42 million people in the United States were unable to purchase broadband internet access. So you may take for granted that given that United States is the most technologically advanced country in the world, there should be no problem with internet access, but that's not true. The pandemic has revealed serious problems, this kind of unequal access to the internet still existing in United States. And it is also a global problem. In 2019, research showed that nearly half of the world's population had no access to broadband internet. And COVID-19 vaccines turned out to be another problem. So COVID-19 vaccine, as you know, is a great technology that has brought an end to the pandemic. But this great technology, actually the benefits of this technology was unevenly distributed in much of the time of the pandemic. So for example, one of the research papers showed that as of September 2021, a mere 3% of people in low-income countries had been vaccinated. So that was in a stark contrast with the 16% of vaccination rate in high-income countries by that time. And governments around the world have paid between 2 and 24 times more than they could be for COVID-19 vaccines. So we have this great technology, but the benefits of technology were unevenly distributed, as you can see from the statistics here. So I was very troubled by these problems and asked myself, what should I do? And then I also thought about the normal situations that we may be dealing with in our daily lives. And I found really serious problems too. And this is because of the social media companies that we have to deal with every day. And so you can see that there's actually a severe asymmetry of power and responsibility that they have. Why is that? I think Facebook is a textbook example about this asymmetry. So Facebook, for example, as you know that they sold a large amount of unprecedented amount of personal data to Cambridge Analytica, so causing the most serious breach of personal data. And also Facebook's mishandling of fake news is said to have swayed the outcome of the 2016 US presidential election. And then it is no surprise that a UK judge even denounced Facebook as a tool for evil in a judicial ruling. And then we also have technology companies that are patent holders. But these companies also have abused their power or intellectual property rights. So for example, you can see that in the beginning of the pandemic, patent owners sued people for using their patents for conducting coronavirus testing. And that litigation was denounced as the most tone-deaf IP suit in history. And another interesting development is about the World Health Organization's initiative, encouraging pharmaceutical companies to share technologies with the global communities. So they established the so-called COVID-19 technology access pool, but no pharmaceutical companies had voluntarily joined this initiative as of March 2021. And some of them even condemned this initiative as nonsense and dangerous. So what shall we deal with these irresponsible use of power or intellectual property rights? Or put it differently, how can we develop and apply technology in the public interest? So I grapple with this central question in my book, and I offered a so-called rights and responsibility approach to deal with it. So as you can see, this approach has two parts. The first part is about the protection of the so-called the right to technology. So I argue that this right could be first protected as a human right under the International Human Rights Treaty, and it could also be protected as a collective right under domestic civil rights law. And I also offer a thought experiment arguing that the right to technology could even be protected as a fundamental right under domestic constitutions. So this is the right to technology part. And the second part is about the enforcement of fundamental corporate responsibility. These are the responsibility imposed on technology companies, requiring them to reciprocate for users' contributions, to assume an active role responsibility, and counter injustice caused by technological developments. So what I intended to do is to set the agendas to protect the public interest in motion. You may argue that we should talk about the concept of the public interest and the technology in the very first place, but I did not intend to do so because as you may know, concepts such as the public interest are the most elusive concepts. But I argue that if we set the agendas in motion through actions, such as litigations, then we can find a way to define technology as well as the public interest. So let me tell you more information about these proposals. So first of all, the human right to technology. This right actually was first created by the Universal Declaration of Human Rights in 1948. After the Second World War, international leaders realized that or technologies, such as weapons, for example, applied in Second World War, actually caused unprecedented harm to human lives and properties. So they believe that technology should be utilized in the public interest. Then they came up with this clause stating that everyone has the right to share in scientific advancement and its benefits. So there's a similar clause in the International Covenant on Economic, Social, and Cultural Rights. So I call this the human right to technology, and surprisingly, more than 70 years since the adoption of the UDHR, this human right actually has become a sleeping beauty or an orphan that I call it an orphan in my book. So, and actually no other human rights have received such scant attention. This right has remained obscure, dormant, and ineffective. So I wonder how many of you have heard about this clause or this right? Just a few. That's impressive, actually. I gave talks in other places, and normally there was nobody raising hand. So Yale Law School is indeed impressive. But you can see that the majority in this classroom actually did not know about this right until I told you so. So there's been serious problems with this human right. So what is going around then? I found that there are three major factors contributing to the near demise of this human right. First of all, this right itself is obscure. How do we define technology? How do we share in the advancement of technology? And these are kind of elusive concepts. And also, as you know, that international human rights system is kind of ineffective by its nature, right? Because it does not have the teeth in enforcement. But what to me, I think the most important or relevant factor is about international communities' overemphasis on intellectual property protection. Because in the past 70 years or so, the international community actually came up with a whole range of treaties protecting or enhancing intellectual property protection. So this means that if you want to distribute benefits from technology development, we are doing so through patent protection. And so when it comes to patent rights, we need access to technology benefits will be licensed by IP owners. So this has kind of led to the rise of intellectual property and then the eclipse of this human right. So what can we do then? How can we resurrect this human right? So I offer a proposal to protect it as a domestic, civil liberty. So this could be protected as a collective right. So what are collective rights? I think I want to talk about in contrast to individual rights. Individual rights normally protect an individual's personal interest, such as interest in property and privacy, right? So it's about protecting personal interests. But collective rights are different. They protect people's interest in their social membership, how they can become members of a community or a society. So this kind of social members is key to the idea of collective rights. So in general, or in my opinion, there are two kinds of collective rights. One is called societal rights. So they protect people's interest to develop a better community or better society. So the right to development is a typical example. So this legal right entitles people to, for example, to utilize natural resources to better develop a society. So, and group rights are designed to protect certain groups of people and the interest held by certain groups of people. For example, a kind of a language, kind of a cultural inheritance, things like that. So it's more or less about protecting group identity. So I argue that if we protect the technology as societal rights and group rights, we will be in a better position to protect and promote the human right to technology domestically. So societal rights to technology basically are designed to enable social members to achieve fair share of technological benefits in the sectors ranging from public communication to public transportation. I think internet access is a very good example. If people want to participate in civic life, so they have to have access to such public forum, right? It's about the protection of societal rights. And then group rights to technology are designed to protect certain kind of group interests. A good example is about, for example, facial technology. Some facial technologies actually are encoded to discriminate against certain races. You have, I think some of you probably have heard examples about, for example, certain facial recognition technology, which wrongly recognize or take it for granted that Black people are criminal suspects automatically, things like that. So that would harm this kind of group interest, and this idea of group rights to technology can be utilized to guard against such practices. So the thought experiment I mentioned earlier is about protecting technology as a fundamental right under domestic constitutions. So how can we do so then? So I want to take advantage of the US Constitution to argue that especially the 14th Amendment, the idea of liberty under the 14th Amendment could be utilized to recognize technology as a fundamental right. So what are the fundamental rights? According to US Constitution, some liberties are so important that they can be deemed fundamental rights. Such these examples are freedom of expression protected by First Amendment and property protected by the Fifth Amendment, right? So these are enumerated fundamental rights expressly recognized by US Constitution. At the same time, the Constitution also protects unenumerated fundamental rights, such as the right to travel, the right to marriage. These are not expressly stated by Constitution, but Supreme Court, by relying on the idea of liberty under the 14th Amendment, have recognized these unenumerated fundamental rights. So my argument that if we could recognize technology as a liberty under the 14th Amendment, we could protect it as a fundamental right under the US Constitution. So then I have a sort of an unrealistic argument about protecting this fundamental right as a positive liberty, requiring the government to provide or ensure equal distribution of technological benefits. Technologies that are fundamental to the sustainability of people's lives and freedom, they should be protected by the fundamental right to technology. So these fundamental technologies include electricity, transportation, telephones, and also internet access. So the governments should provide, for example, electricity to everybody through various means, right? Or public transportation, telephones. But we are not saying that the government should provide, for example, Mercedes-Benz, buses. The government should provide iPhones to, each citizen. We're talking about, for example, providing some basic infrastructure so that everybody can, take advantage of it. So this is the idea about fundamental right to technology. So let me move on to the second part of the proposal. It's about the imposition and enforcement of the so-called fundamental corporate responsibility. So the first argument is that we could rely on the ethical norm of reciprocity to require tech companies to reciprocate for users' contributions to their development. So reciprocity, as you know, is an ethical norm requiring that we should respond to a positive action by another through returning that action proportionally. Friendship is a good example. Friendship is normally fostered by this norm. If a friend treats you a dinner, gives you a gift, normally you should reciprocate. Otherwise, it will be very hard to have some proper, friendship. So users' contributions, in my opinion, are very important to the growth and development of technology companies, especially social media platforms. First of all, users have contributed a lot of content to platforms. For example, we have uploaded so many videos, so many posts on social media platforms, YouTube, Instagram, Facebook, right? And users also have made contributions to tech companies' advertising revenues. So advertisers know that social media platforms have a lot of users, right? Okay, that's why they may prioritize these platforms in advertisement. And also users have made a lot of contribution to tech companies' innovation. I think nowadays, the development of artificial intelligence technology such as ChatGPT is really good example. Users contribute a lot of data to the development of AI, right? So training of machine learning algorithm, all kinds of things, you need data from users. So that's why by relying on this ethical norm, I argue that tech companies should reciprocate for users' contribution. And good argument is that they should protect the users, for example, data with a lot of care, okay? And secondly, they should also assume an active role responsibility. So role responsibility is an idea that first put forward by a British jurist whose name is H.L.A. Hart. So in his very early work, he argued that responsibility can be imposed upon a person based on the roles such as husband, sea captain, or judge. A husband is supposed to, because of this role, he is supposed to support the family. A sea captain is supposed to take good care of passengers. A judge is supposed to make decisions, in an impartial manner. And so technology companies' roles are very important. And so first of all, if we take a closer at their roles, you can find that they, first of all, they play the role of disseminating information. They are information disseminators. So I mentioned earlier that users upload a lot of information on social media platforms, right? So then social media platforms disseminate information as such. And they also play the role of collecting information from users. So this is the second role they have as information collectors. They also create informations. And again, artificial intelligence is a very good example. ChatGPT is creating a whole range of information, right? Okay. So then by drawing on the role responsibility idea, I argue that tech companies should assume an active role responsibility. So last but not least, I also argue that tech companies should confront injustice caused by technological developments. So social justice, you know, is one of the fundamental values that we care about tremendously. Conventional idea about social justice deals with resource-based injustice, unequal distribution of resources such as property will cause social inequality. At the same time, unequal recognition of social status such as racial discrimination will also cause social inequality. But then I also think that technology can also cause social injustice. So I call it technology-driven injustice. We have resource-driven injustice, we have status-driven injustice. Now we have technology-driven injustice. So how can we understand it? For example, access to technology benefits, as I mentioned earlier, has been, unequal or uneven in many ways. So this has been really a fundamental problem existing in our society. I've already talked about a number of examples. And then at the same time, use of technology itself can also cause injustice. A good example is about environmental pollution. One's use of technology could emit a lot of pollution to our air, to our water resources. So we really need to think about it carefully, and use of, for example, overuse of improper use of social media could have caused harm to students, their obsession with social media. You probably have heard a lot of examples about these problems. And so I also had the last quick thought to share with you about pen holders' responsibilities. So last chapter of the book deals with how we can deal with pen holders' responsibilities. And I draw on the three ideas: reciprocity, role responsibility, as well as responding to social injustice, to argue that patent holders, tech companies, as patent holders, they should also assume these responsibilities to promote equal access to technological benefits. So these are what I wanted to share with you, and I look forward to questions and comments. Thank you very much.